it's really important, this being a conference about transparency and technology and policing, to talk about some of the defects of facial recognition. I want to say, first of all, that I know Jennifer, I know everybody in that office at MSP who does this work. I think they are people of good faith who believe in this technology and are attempting to use it in good faith. I will also say that after the settlement in Robert Williams in our Detroit case, I've brought many of the concerns I'm about to share here to the MSP, and they've exhibited some willingness to listen to them and maybe to change some of their practices. But with that said, they haven't yet changed, and I have a number of really deep concerns, and I think they need to be shared. So what you just heard is this sort of vision of facial recognition in which they do this search, they do a morphological comparison to confirm it, they send an investigative lead. Officers understand that this is just an investigative lead and go out and do a really thorough study. I just want to say everything that was just described, that stuff was done in my case. And it still resulted in the false lead, the erroneous lead. It still resulted in the arrest of Mr. Williams. And that's because of all the things that weren't just discussed that can go wrong and do go wrong. So let me start with a deeper dive. And by the knowledge I have of this is specifically knowledge about how Michigan uses facial recognition technology, and it is information that came out in the course of our litigation, so that's my source for this. First of all, so when they do that search that was described, they get a probe photo. Let me start with what goes wrong there. You were just told that they will reject a probe photo if it's poor enough quality, and you had a couple images of like really bad quality photos. Okay, they will reject the worst quality photos, but they don't have a technical standard for that. It's eyeballing it based on the facial examiner's judgment. In our case, and in many cases, they still ran it on a poor quality photo. In fact, on the morphological comparison sheet that is turned around, where they sort of identify each of the facial characteristics, they look at the eyes, they look at the jaw, all that things, there's a box where you can check the quality of the photo. That box was checked quality poor, but they went ahead and did the facial recognition search anyways. We showed that facial recognition search to our expert witness. Our expert witness is not a hippie anti-facial recognition person like me. It is a CIA, a guy who has developed and used facial recognition for the CIA. He broke it down by the pixel length. There are these technical things they could use to determine whether or not a photo is of sufficient quality. And he said that facial recognition technology could not possibly operate with any reliability on that pixel length. That is not an analysis that happens before they decide to use a probe photo. And you saw, this like image of like a perfect little probe photo, and there are these like face, these like beautiful, like got the shoulders, the head, the way you take your passport photo. Facial recognition technology is reasonably good, although it still has significant racial disparities at these sort of direct on straight shots. That's actually not the vast majority of real world shots that you get in facial recognition. The much more common thing you get in facial recognition is a video footage of, like overhead, maybe the person has a hat, it's dimly lit, all of these things that can obscure or make a facial recognition search less successful. So that's at the very opening step, things that are not happening before probe photos are used in facial recognition. Another point I want to make is, Jen said, and this is absolutely true as far as I'm aware, that the Michigan State Police are not using facial recognition on real-time surveillance and not outside of an investigation. And by the way, Detroit also has a similar position. But I urge you to question how quickly we can flip these things, and also to question what people intended when they originally purchased. So this is not about Michigan State Police, this is about DPD. DPD, publicly represented time and time again, we are only in this technology to take a still photo and investigate a crime. And then when I FOIA'd, used the Freedom of Information Act request to get their contract with the original facial examination company, which by the way is the same company that MSP uses. Written in the contract as a project objective was identification on real-time green light camera footage. Now, I don't believe they're using that because I think there was public pushback once the public found out that FRT was being used. But the purpose, the things that these are being marketed for by the same company that is being used throughout Michigan is absolutely this. And the technology is like they think their technology can be used for this, and they are encouraging their technology to be used for this. So I want to be very clear and say, don't believe MSP is doing that. I appreciate that. I think they have the right steps in place so that they're not doing that. But you know, we need to be very cautious as the citizenry that you know, there are forces pushing to do that. So next, let's talk about what happens once that facial recognition search happens. Okay, so you heard Jen describe that they do a search and they get 3 different galleries of 50 photos. That's actually changed a little bit when they did Robert Williams' search. They got 2 galleries of 243 photos and a 3rd gallery of 50 photos, so it looks like they've changed that down to 50. The reason they get 3 is they're doing 2 different things. One thing is they are probing the FBI's facial recognition database. And they're saying, hey FBI, can you give us back 50 matches from your database? Then they are running a search across that SNAP database that you asked a question about, which includes every single one of our driver's licenses, every single one of our expired driver's licenses since 1998. And they're actually running that with 2 different algorithms. So the algorithm is like the equation, and they're sold by 2 different companies. So they have 2 different companies basically that go out and do the math and try to like identify matches. And each of those 2 companies then spit back separate galleries of 50. So now you've got maybe 3 galleries in front of you, 1 from the FBI, 2 based on the SNAP database. Okay, you also heard Jen say, but sometimes it doesn't return one. What she didn't say is why it doesn't return one. When I asked MSP why don't they return them, they didn't know. But the most likely reason is because the algorithm has deemed the photo of too poor quality and therefore hasn't returned any searches. But they're not asking that question. When somebody asked the question about, like, you know, who's in the room with the developers, what questions are being asked, they didn't know. They didn't know why they don't get back results. And they don't question whether or not that might be because the result is poor and whether or not that should slow down or pause moving forward with facial recognition. Now let's talk about what happens with the galleries and that morphological comparison. Okay, what they don't do, so that when they get back the galleries, they're appearing in order the computer calculates basically like a reliability score, essentially how sure it is. So they're like moving down that list. Jen just told us that, that they do a morphological comparison on everybody. That's definitely not what they were doing when they were using this technology with my client. Maybe they are now. If so, it's really hard to believe that they can do 11 a day, because if you've got 150 faces and you're doing a detailed analysis, I struggle to see how that could happen at that pace. So I suspect that was probably like a misspeak. Again, I want to be very clear. I think everybody in this, I think MSP is trying to solve crimes. I think they have good faith. I just think they're using a dangerous technology. That morphological comparison, first of all, is likely not happening on all of the photos. And then there's a whole bunch of indicators that they could be looking at to increase the reliability of these searches that they're not. Recall that I said, in the SNAP database in particular, they've got 2 different sets of math analyzing that database, right? So like, you basically get 2 tries. They do not have a practice of checking if the same photo that they're identifying as a lead is showing up in both of those algorithms. If this technology is as reliable as we want to be led to believe that it should be used to initiate an investigation, wouldn't you think that 2 different people kind of doing their math and like kind of putting it through might reach somewhat similar results? That would be my sort of layperson's reaction, but that's not a question that's asked. Another thing that, and I think MSP is improving on this in fairness, and I think they're improving on it precisely because they learned from Robert Williams, the next thing I'm about to say. They have all of our driver's license photos since 1998. The match to my client was not his current driver's license photo. It was his expired driver's license photo. His expired driver's license photo showed up 9th on one of the galleries, only one of the galleries. His current driver's license photo showed up on none of them. And while they have the capacity, they have the technological capacity, they can click on that person, they can say, how many other photos do we have of that person? Did any of those photos show up? Maybe we should look at those photos. They do not have a requirement that they do so. And in fact, did not do so in my client's case. And when you look at a lot of the facial recognition checks going wrong, many of them are to older or expired photos, which is no surprise because unfortunately, I don't look the way I looked 7 years ago, and to any of you who do, bless you. You also heard about the supervisory approvals, and again, I think this is done in good faith, but let's be clear about what happens with those supervisory approvals. It is not a supervisor gets the whole gallery and looks again. It is the supervisor gets the match that the examiner has chosen, and the supervisor either gives it a thumbs up or a thumbs down. I, for one, don't find that a particularly compelling check on whether or not facial recognition has gone right. I mean, I think it's better than nothing, but I think it's a problem. Next, there's the communication with police departments. And I mentioned this during the chat earlier, you know, when an investigative lead is sent back to a local police department, let me pause. Except for Detroit and maybe a couple other places, but Detroit that I know of, most police agencies who use facial recognition in Michigan do so through MSP, as you know, Jen kind of alluded to, right? They send a search, they say, can you like help us solve this crime? Here's a photo. And then so they get sent back this thing that's an investigative lead. Okay, things they don't get sent back, that morphological comparison, which among other things has the checkbox about whether or not the photo quality was poor. So they don't know if the search is based, is a better or worse search. They don't get sent back the gallery of other possible leads, you know, to the people who were excluded. And I understand that there's actually a purpose of that, of like, we don't want to send, you know, like the police chasing after a bunch of people who didn't do anything, but they can't even ask for it, it's not available. In fact, MSP is so closed down on these that when I tried to obtain the gallery in my client's case in a lawsuit I had actively going in federal court, MSP's lawyers told me we will not turn over that gallery to you because of privacy concerns and in our contracts with the facial recognition companies and the like proprietary stuff. So like this stuff is locked down and it is not shared so that somebody, so that a cop could maybe look at that and make a common sense judgment of their own about how reliable the information they've just been given is. And it's definitely not given to criminal defense attorneys who might have a reason to be saying like, hey, they started investigating my client, put him in a lineup because of because of facial recognition. I'd like to like kind of get to the reliability of the facial recognition and understand that. In general, the use of facial recognition isn't disclosed to defense attorneys at all if it doesn't happen to be in the warrant, but they definitely aren't disclosing information that I think is in their possession that every defense attorney who's defending a client who came into law enforcement's eyes because of facial recognition, I think is entitled to know and should have the right and ability to question. There is no disclosure to local police of the fact, as everybody in this community knows, that facial recognition simply is less accurate on faces of color, particularly black faces. It's less accurate on young people, it's less accurate on non-binary people, it's less accurate on older people, basically it's less accurate on everybody except people who look like me. None of those things are disclosed. And that means none of those things are disclosed to courts. If courts are asked to issue a warrant based in part on facial recognition. So I apologize, I did not come up here meaning to, actually by the time I walked up here, I meant to do what I just did, but I think it's really important to take this moment, since we just heard about this technology, to really drill down into the details, because I'm deeply, deeply concerned about the details, and I think the details matter a lot in the way we use this technology. I'd be happy to take questions or criticisms of any of that, and if people don't have them, then I'll turn back to the presentation I intended to give.
So thank you for the important information. I love that there's a balance. There's truth coming through a lot of information. I was curious about the fact that there's no policy that says if somebody's face comes up and there's 10 other photos of them, that they click a button to find those. How does one change those policies? Are they departmental? Are they, licensing? How does one then?
Yeah, this one's pretty easy. This one, because MSP is doing most of the facial recognition for most of the state, MSP just needs to implement a policy on that. And I will say, I said I am speaking to MSP about this. I believe they will implement a policy on this based on my conversations with them following the Robert Williams settlement. I mean, after the Robert Williams settlement, we've gone to MSP and said we think there's a lot of good stuff in here, a lot of like good, important stuff. Most importantly, I mentioned breaking the tie between facial recognition in lineups this morning. That should be definitively broken, but also disclosing a lot of this information that is out there, and also so we don't have in the settlement this requirement of looking at the other photos. But I do think that's a simple policy for MSP to adopt, and I am actually pretty optimistic that they will. But I think by all means, write your legislator and say something about it. But I'm working with them on that. I came up here a little hot on this issue, but I do want to say, like, again, the folks who are doing this in MSP, they are people of good faith who believe in this technology, and I think don't want to get it wrong. Like, nobody likes to see a headline like Robert Williams in the paper. Nobody likes to see a deposition notice from me. So some things we're never going to see eye to eye on, but some things, when I say to them, I think this is a problem that should be addressed, I hear serious responses, and this is one where I'm hearing a very serious response. But it does make me think that this sort of connection with the local police. Another thing that I think MSP could be doing and is not is, so they send these investigative leads out, and they say don't use this as the sole basis. And I would say they agree with me, and I don't believe that MSP officers at this point are likely ever moving straight from facial recognition to a lineup. But meanwhile, they're providing these leads to every local police department throughout the state of Michigan. And those local police departments have no obligation to do that. And as of now, MSP has not set up any system for disciplining or cutting off from access to the technology police departments who do that. They do attempt to sort of follow up occasionally on, hey, how did our lead go? But if they don't hear back, that's sort of it. And they have a limited audit process, but the audit process isn't actually looking for this. So I think MSP can and should have a policy that is, look, if we give you this, we want to know what the follow-up steps were, and in particular, if you go do a lineup based only on facial recognition, which is a proven bad idea, then you cut off. We're not going to do facial recognition for you anymore. I think that's something they can and should be doing. I just spilled water all over my computer, so we'll see if I can still put up a presentation or not.
I have so I know that there's all this talk about policies for this stuff. Can you say anything about any laws that could be passed?
Yeah, everything that I just said should be MSP policy, can and should be Michigan law. So the legislature could require all of these things as well. Thank you so much. It's a good point that we don't need to only rely on administrative level policy, but could in fact look to our state legislators. We've been working for years in the legislature to try to get a moratorium on the use of facial recognition technology, at least until racial disparities can be addressed, particularly racial disparities. I mentioned the passport style thing is really good. The real world conditions are worse. When I, in settlement discussions with the city of Detroit, said to them, hey, how about we put a pause on this technology until there's a study that shows it's as accurate in the real world for people of color as not. They said, well, that's a poison pill. That can never happen. So, yeah.
What about restricting the use of facial recs to different kinds of things? I mean, if you've got an unidentified dead body, for example, you could take a really crisp picture and take it square on. And it seems to me that the chances of creating harm that way are pretty small.
I think that's a great point. There's a difference between using it to identify a victim, where the likelihood of a false identification isn't likely, the cops showing up on your front lawn and perpetrating an arrest, versus using it to identify a suspect. So I think that's a thing to think about. Another thing to think about would be much tighter controls on the use of photo if you are going to use it in investigations. One thing I would caution thinking about, because it was not in place at the time that the facial recognition search in Robert Williams' case was conducted, but subsequently, and before we sued, Detroit had changed their policy to only use facial recognition in home invasion and investigates those particularly violent crimes. Let me say I understand where that impulse comes from, and I appreciate it. Like, my client got falsely arrested for supposedly stealing a Chanel watch, which seems particularly silly reason to have had his life upended and be arrested on his front lawn in front of his 2- and 5-year-old daughter. But, you know, as my client has said in many interviews, said, you know, thank goodness I didn't get falsely arrested for carjacking, because I might still be in jail, or I might have been forced into a plea bargain. You know, there was a wrongful arrest in Detroit pretty recently, based on for carjacking. After they changed it to, you know, only be for serious crimes, they arrested a woman for carjacking based on a facial recognition combined with a lineup, and ignored the fact that she was 8 months pregnant at the time of the arrest, and would have been 7 months pregnant at the time of the crime, and that the video footage very clearly did not show a 7-month pregnant woman. So, you know, like, that woman was also, like, as horrible as what happened to her is, she's damn lucky she was pregnant. Because if she was not, they had a lineup ID that they were going to go to court with. And if you go to trial with a witness IDing you, you're rolling the dice. You know, she could prove it wasn't her because she was pregnant. But for her being pregnant, she might have been taking a plea bargain or might be in jail for carjacking today. So I kind of want to like just put up a big red flag to like that particular limitation as I understand where it comes from. It's, you know, let's like minimize the use of this and only use it when we're trying to solve the most like egregious of the crimes that most implicate public safety. But so too, a wrongful conviction in that context is all the more you know, ruinous of someone's life. Thanks. Anything else on facial recognition?
I do want to ask, do you think that it's possible, I think you mentioned state law as a potential way to have some safeguards in place outside of administrative policy? But what about local level, like municipal level?
Yeah, 100%. Municipalities can do this. I mean, tomorrow the Kalamazoo, I mean, I think you heard from the local law enforcement folks here that, you know, Kalamazoo is not using this, although I think there's a caveat on that. I think they can still send a photo to MSP to be used, but there's nothing that would prevent the Kalamazoo County Commission from passing an ordinance tomorrow that says, you know, we won't use facial recognition technology in our community, which you don't, but also, you know, the police are instructed not to rely on it from any other source as well. So yeah, that type of thing can be done. And if it is to be used, then the types of restrictions like we have incorporated into our settlement in Detroit require disclosure of critical information and that require not moving from facial recognition straight to a lineup. There's no reason those things can't be done through local laws where state level laws aren't doing it, which, you know, they're currently not in Michigan. Okay, so I had intended to come to discuss in general the Fourth and Fifth Amendment and police technology. So let me put this in presentation mode. There we go. Okay, so most of this is about the Fourth Amendment. I will try to get to the Fifth Amendment. For those of you who aren't constitutional lawyers in the crowd, the Fourth Amendment is the general restriction on seizures and searches, and most of the source of privacy in the federal Constitution. The Fifth Amendment is about due process. It's about a bunch of other things too, but due process as will be relevant here today. So in terms of the Fourth Amendment, this first point this is just sort of a point about how courts think about the Fourth Amendment. When they analyze whether or not something is a search and whether or not you have to have a warrant to go conduct a search. And there's two tests that courts use. One is whether or not there has been a physical trespass. So classic example, police officers walk into your home. That's a trespass. That's your property. They need a warrant to do it. This is one that it's where as the law continues to evolve, and it does here, this is where conservative members of the U.S. Supreme Court are most focused, is on this physical trespass test. Traditionally, that test was actually sort of the less important test, and the more important test since about the 1940s has been whether or not we have a reasonable expectation of privacy in the type of information that is being searched or sought. This is like, it's a little bit of a circular exercise if you're a judge, because you're trying to decide whether or not we all think something is private, and your decision as a judge will in part determine whether or not we think it's private. So it's a little squishier that way. But this was born out of wiretaps, which basically said, look, your phone conversations. We might not have to physically trespass in your home and grab your phone out of your hands in order to hear it, but we are going to recognize that you have a reasonable expectation of privacy in your private phone conversations. Do people think they have a reasonable expectation of privacy in their garbage? Couple of reactions, no? No, you don't have a reasonable expectation in your garbage, according to the US Supreme Court. And that garbage case is actually a really, really important case, because the garbage case is basically like, well, you got rid of it. Well, the things you get rid of, the data you get rid of that you share with someone else, the DNA that you shed, things that you get rid of, you might often think you might as a just regular person walking around with your own sense of privacy feel like that stuff's pretty private, but the courts aren't necessarily going to get there. This has traditionally been the focus of the more left side of the court. So just putting that out there. Okay, so in 2012, the United States Supreme Court had a case before it, which was about the police attaching a GPS tracker to a car. You think the courts analyzed that as a physical trespass, or about the reasonable expectation of privacy in your car? Physical trespass? The answer is both, actually. This was an interesting case. Basically, everybody on the court thought there was a problem with it, but they didn't write a majority opinion because just under half the court thought that it was a physical trespass. Well, everybody in the court actually thought it was a physical trespass because the police had to physically affix the tracker to the car. And a lot of them thought it was a reasonable expectation of privacy. But it just kind of shows that there's these like two different ways of thinking about it that courts analyze very differently. And I bring this up because now just kind of like I want to march through like what courts have said about a few particular areas of technology, and which of these tests they analyze them under becomes interesting and relevant. So there have been two big cases in the past 15 or so years about cell phones. And Lisa mentioned one of them this morning, probably one of the most important Fourth Amendment cases of the 21st century. It's called Carpenter versus United States. Carpenter versus United States is about the ability of the police to request from cell phone companies the data about where your cell phone has pinged, and therefore essentially track your whereabouts for as long as could reasonably be imagined. By the way, interestingly, this case was about a guy who stole cell phones from a cell phone store, so it's not history. So, and the defense, actually, the government's view here was, this is just like the trash case. You don't own your cell phone pings. Your cell phone pings are just like, they're things that are shed off of your phone as you go about your day. They're not even in your possession. They were never in your possession. They're in the possession of the cell phone company. So this was actually a really hard case for the US Supreme Court. And they issued this decision, which is hugely important and says you do have to have a warrant to do it, but it was also, the court was obviously a little scared that they were kind of like in tension with some of their older cases, so they put a bunch of hedges in place. And the particular hedges that are really important is they did not reach the question, so this remains an open constitutional question, of whether or not a warrant is required for searching for your whereabouts for less than 7 days. So if the police want to know where you've been for the last 5 days and ask Verizon for that, they may not need a warrant, and that issue is sort of percolating through the courts as we speak, and someday we'll come back to the US Supreme Court. The other thing is, they said, we're not saying that there's a limitation on the ability to find everybody who's in a particular area at a particular time. So, okay, we want to know who stole the car that you saw on the video footage this morning, and we want to find out every Kalamazooan, call yourselves Kalamazooans, sorry. People from Kalamazoo. We want to find every person from Kalamazoo who was within a mile of that location. That, as of now, does not require a warrant. So that is Carpenter. The other really important cell phone case is Riley versus California. There's a general doctrine that when you are arrested, the police do not need to go obtain a warrant in order to search your person and all the things on you. They can go through your wallet, they can check the pockets of your clothes. On a more or less common sense notion that once you're in custody and arrested, we can do these things. And so under that principle, police have taken the position that while you're arrested with your cell phone on you, we can search everything in your cell phone incident to your arrest. And if you were just sort of playing it straight on what the court had said previously about searches incident to arrest, the government was probably right. This wasn't a crazy position for the police and the government to be taking. But this is a case where the Supreme Court was willing to sort of look differently at things in light of the many unique traits of these little toys we have. And they were like, look, the home is the most sacred place from a perspective of the Fourth Amendment. We require warrants there. And there is more information about most of us in these phones with all of the apps and our email and our banking and every single other thing that we are going to say, no, that's different. You can take the cell phone from them, but to search it, you need a warrant. And this is a really interesting, important case, partly because it's just the Supreme Court not taking a really legalistic look at this, but being real about the power of cell phones. And so hopefully it is an indication that in the future the court will continue to take seriously the deep, deep privacy implications of evolving and new technology.
I have a quick question for you. Sorry to interrupt.
Yeah, please.
When they say the entire phone, is that different than saying that, or say your messages or whatever app I've been open and talking?
Yeah, that's a great question. So these things are actually being litigated now. There was a case actually in the Michigan Supreme Court a couple years back, which is basically when you get that warrant, it can't just be a general warrant. A general warrant to we want to search everything in the phone is akin to a warrant that just says we want to turn everything over in your house and we're not saying what we're looking for or what areas of the house we're searching for. And there's limitations on that. So we're going to treat your phone like that. The warrant needs to sort of say we're looking for emails of, with the following 10 co-conspirators, or, we're going to search your calendar because of this. So I will say my colleagues or my friends who, do public defense work tell me that this is sometimes honored more in the breach than in spirit in the lower courts. But at least the Michigan Supreme Court here in Michigan has made pretty clear that the scope of the search needs to be articulated and needs to be reasonably tethered to finding incriminating evidence. So at least the law is there. Whether or not the practice is caught up is, I think, a significant question. We've been talking about surveillance cameras a lot this morning, so I think this slide is particularly important and relevant for everybody here in Kalamazoo. There's an issue that has percolated, has not yet made it to the Supreme Court, that's sort of about what about permanent security cameras kind of pointed at our property. This case that's cited here, United States versus Mayshaw, is about a person who lived in an apartment, and the police had some suspicion of him pointed 24-hour camera at his carport, in his apartment complex. And what the Sixth Circuit, which is the federal court that governs Michigan and neighboring states, said is, well, a policeman could have done the exact same thing. A policeman could have camped right outside your carport. They didn't have to they didn't have to walk into your home to do it. And since it was in principle viewable by a policeman, even though that wasn't a practical thing for the police to do, we're going to say there's no Sixth Amendment implications. Left unresolved is what if the camera had sort of been pointed high and past a hedge that you couldn't see from the street? What if the camera was looking into a window that you could see from the street, but now you're looking into the house? And the court hasn't answered those questions, but those questions will continue to percolate. Another thing about long-term cameras is when we might see cases start to arise that start to invoke this Carpenter logic. Carpenter, again, was that case about the cell phone towers, and part of the reasoning of Carpenter was with that data, they can literally tell everywhere you've been all of the time. So at what point and at what density of cameras in downtown of Fusus being able to know everywhere we went, and how many of the Fusus cameras have to be cameras that allow the police to access them automatically versus because of consent of the store owner or the homeowner? Are we going to get to a place where a Carpenter-like argument might start to prevail. I don't have an answer to that, except to highlight that that's sort of like something that people like me and Lisa will be litigating about and thinking about and watching for as the years go on and as technology sort of encroaches more and more and more into being able to give a whole image of view of where we are and where we've been. By the way, I really appreciated the question this morning, or the back and forth with the chief this morning about the way Fusus is used, because I want to highlight something that I think is happening in Detroit that's really concerning, which is they've got these green light cameras, and the way the green light camera, there's a bunch of things about the green light cameras that bother me, but one that particularly bothers me is they provide better policing. So the chief mentioned that they get these virtual patrols, but it's also that their calls for service get higher priority. So if you're a gas station owner who has signed up to the green light program and paid money to install your camera, which by the way, if you do that, you are providing a 24/7 feed to DPD that they can access anytime. It's not the sort of back and forth consent like the chief described that you have here in Kalamazoo. And if you don't sign up for that and you want to call in a carjacking or a robbery, your call to 911 is deprioritized. Pay me money if you want to be safe. Sounds like a racket to me. And I think it's really disturbing for a public protection agency, and I want to be clear, this is about Detroit. This is not about Kalamazoo. This is not about Michigan State Police, who I don't believe are doing anything analogous to this. But it's a potential direction that these things can go in the future, so I think we should look at it. I think that's really concerning. That you get better police protection if you pay more for it, and if you waive your Fourth Amendment right to not have your property surveilled. So just to flag that that's a surveillance camera issue. Okay, these next two examples I just want to briefly hit on as sort of interesting examples about how the physical trespass versus the privacy claim go. So we litigated a case just a couple years ago in the Michigan Supreme Court. The Grand Rapids police had fingerprint readers. These are mobile fingerprint readers. It's either an app or a separate device. You just bring it up to someone, you say, here, put your finger on this, and you press your finger, and they can do a real-time fingerprint search. The Grand Rapids police were documenting their use of this, which is fortunate because we were able to find out what's in this first bullet point, which is that 75% of the encounters where they were fingerprinting people were with Black residents of Grand Rapids, despite Grand Rapids being only 15% Black. And the people who were being targeted by this technology included our two clients. One was, I believe, a 15-year-old young man who was walking through a parking lot, and the officer thought he maybe looked at a car funny and might be a car thief because there had been cars stolen from that parking lot at some point, and so stopped him, detained him, and fingerprinted him. The other was a young Black youth who was sharing a toy with another child, and the police concluded that he must have stolen that toy, and so stopped him and detained him and fingerprinted him. We went to the Michigan Supreme Court. We said, this can't be, you're doing this without anything remotely resembling probable cause that is necessary for a warrant and a search, and the Michigan Supreme Court agreed with us. But interestingly, there's this sort of common sense, I think, that many people, at least in this room, will feel there's something wrong about that. But it's actually a really hard legal question whether that's a search. Because it's not me walking into your home, it's not even me opening up your phone and rifling through your things. So we won this in the Michigan Supreme Court, and we won it because you went this, not this. Because this is a physical trespass. We were physically contacting you. The officer has to depress your finger onto the technology. I will say, I don't think that captures what I think is really wrong about the fingerprinting. It's the invasion of the privacy rather than the physical touch. And there was a separate concurrence in that opinion that said that if they reached that issue, they might also agree with us on that issue. But it's just I just sort of bring this to your attention because I mentioned at the end of the session in the morning, the Constitution isn't always going to save us. Sometimes the constitutional question can come down for lawyers in the courtroom to a hyper-technical point that I think doesn't reflect what we in the public feel about what's really at stake in the Fourth Amendment. Just a kind of fun case about reasonable expectations of privacy. So another piece of surveillance equipment, this one's a bit old, it's not really at the cutting edge these days, but it's thermal imaging. You basically point a thermal imager at a house And police would use this to try to find grow houses, like lots of UV lights and trying to grow large amounts of marijuana. Case went up to the U.S. Supreme Court about whether or not that was a search. And it was not a trespass because it's just pointing a little gun that nothing actually penetrates the house. It's actually reading the emanations of heat from the house. And so the government had an airtight argument that there was no trespass here. But the Supreme Court actually, in an opinion written by Antonin Scalia, who is not known as a fan of the reasonable expectation of privacy test, but interestingly was known as a fan of the Fourth Amendment, wrote an opinion saying, no, this does in fact invade our reasonable expectations of privacy. But I also want to pause for a second on how you win a reasonable expectation of privacy case. And one of the best ways to win a reasonable expectation of privacy case is to really appeal to what a highly propertied older white man might perceive of as being an invasion of their privacy. And I think that's really telling in this quote that I've stuck in here. This is really where, Justice Scalia is trying to get to the heart of why he feels like your privacy has been invaded. The Agama Thermovision 2010 might disclose, for example, at what hour each night the lady of the house takes her daily sauna and bath, a detail many would consider intimate. So this is really important when you get to privacy invasions of folks who don't have the same property. A homeless person who is living in their car. The US Supreme Court has time and time again said we have severely reduced interest in privacy in our car. Well, they don't care if it's your home, and they don't care what that might reflect about class or race or that person's expectation of privacy, because they have this very traditional sense of privacy that is grounded in a particular worldview. Some other Fourth Amendment technologies whose implications remain unresolved. Okay, facial recognition technology, I won't keep talking about that. Shadow dragging, this one hasn't come up today, and I think this is super, super scary, y'all. This thing, shadow dragging, is basically you enter a person's name and it scrapes and searches every social media app out there, tax records, property records, all of the data and information that you shed about yourself onto the internet. It's scraping it together so that the police, and I believe, at least as of a few years ago, I believe Michigan State Police was actively using this. The MSP folks can correct me if I'm wrong about that. And it basically allows them to build a deep profile of all of the information about you that is shed on the internet. And for those of you who are worried about being targeted by the ad for a chainsaw, there's a lot of information about you on the internet. And when I want to go into court and say, hey guys, there's a Fourth Amendment implication here, you need a warrant to put Carlton's name into shadow dragging. The answer is going to be, and at least right now I believe the courts would be likely to accept, this is all shed information. It's like throwing your trash out. You've put it out on the internet. You put it out on the internet and you knew anybody could search for it. It's well, okay, but I wasn't anticipating shadow dragging. So shadow dragging. Drones, this was talked about. There's obviously, I think there's a very real use case for drones, as you saw this morning. I also think it wouldn't be that bad to require warrants for them in non-urgent situations. And I want to highlight a case that recently went up to the Michigan Supreme Court about drones. There was a town in northern Michigan, Long Lake Township. I don't remember the name of the township. A township in northern Michigan that was using it to enforce civil codes against a guy who they thought had too many spare cars, dismantled cars on his property. They complained about it, so he moved them out of his front yard, and to find out if they were in the backyard against what they thought was local code, they flew drones over his home. We filed a brief in the Michigan Supreme Court about this, saying, look, this is too much. And the court didn't actually even reach if the Fourth Amendment had been violated, because it said even if the Fourth Amendment has been violated, this is a civil case, and the remedy of suppressing illegally obtained evidence isn't available in civil proceedings. So we're not going to do anything at law to stop drones from flying over your house to collect information from the government for civil enforcement. License plate readers also talked about a lot today. I just want to kind of make one interesting point about these that wasn't really covered. This is with no knowledge of whether or not Kalamazoo has these capabilities, but some of these programs, including the one that Detroit recently invested in, also let the police search for things like your bumper stickers. So it's not just capturing who's going where and when, but also things that can be deeply expressive. At least the capabilities are there for that. So very quickly, I have 4 more minutes. Do algorithms in the Fifth Amendment. So I mentioned the Fifth Amendment is the due process clause and a bunch of other important things. But the due process clause guarantees us due process of law. And the rise of algorithms in all kinds of ways. I only have 2 examples here, but y'all, this is coming in every decision government makes. But 2 contexts in which algorithms are being actively used that I think raise sort of canary in the coal mine kind of warnings that we should be looking out for. One is in bail and risk assessments, and I will say this I do not believe is being done actively in Michigan, which I appreciate, but it is being used elsewhere. Basically, bail, right, is when you've been arrested for a crime and a judge is deciding whether or not to release you while you await trial. And at least on paper, the standard for holding you while you await trial is supposed to be quite high. There's supposed to be, or ought to be clear and convincing evidence that you're a flight risk or a danger to the public while you're incarcerated, and you're presumed innocent, of course. And needless to say, sitting in jail while you await trial has all sorts of terrible implications for your life, including, by the way, your ability to actually build your defense, because it's much harder to meet with defense counsel during that time. So a lot of jurisdictions have started asking algorithms to make determinations about like a risk factor, basically decide if you're high, medium, or low risk based on a number of variables that it might input. And one of the things you have to ask in anything that is a government-driven, algorithm-based decision is what are the inputs and what are the biases that might be going into the inputs and how might they be replicating back out biases that we as a society taught it. Just to give one example, a classic thing that goes into every type of model that does these determinations is criminal history. If you believe, as I do, that certain segments of our population, in particular the Black community, have been over-policed and over-arrested for the same types of offenses that are being committed in other parts of the community, especially nonviolent offenses, at a higher rate, then you have sort of, it's a garbage in, garbage out problem. You've got, people have criminal history, and it's more often that people of a certain demographic group have have a history like this. That is going to yield a higher likelihood of a result on the back end. Or another thing it looks at is affiliations, or the neighborhoods you live in. These are things that the question can be asked, that the risk assessments can be asking, that obviously are correlated to facts that themselves may be replicating biases that are already present in society. The last thing I want to say on this, many people may remember that about a decade ago, the state of Michigan adopted a technology in an attempt to cut back on unemployment fraud, claims for unemployment. And they built an algorithm and set the algorithm loose on this. And the algorithm made determinations of fraud and sent automated notices out to people. And by the way, it sent the notices out to like a portal where you went and got your benefits. So if you got your benefits 2 years ago and never checked the portal after that, why would you? Your notice that you had been adjudicated as a fraudster by a computer went to a portal you weren't checking anymore. And the next thing you knew, the state of Michigan was at best garnishing your tax returns, perhaps coming like more directly after you for money. This led to lots of bankruptcies. It led to a few suicides. In the fallout of this, approximately 40,000 people are believed to have been falsely accused of unemployment fraud. And people who, we're talking about unemployment. This is a moment when the government's supposed to be giving you a helping hand. And through the use of an algorithm, we turned it instead into like a punch in the nose as you're trying to cling to the ladder of life. So we need to be very, very careful about this. And then just like sort of as you think about these problems, one problem is asking like how do we replicate our own biases in the algorithms? Another is how much does a human need to be in the loop to eliminate due process problems? And this stuff is not even close to worked out by courts yet, but it is an issue that we as a society need to be thinking of, and we need to be thinking of it with a careful eye on the issue discussed during the panel this morning about how like the automation bias and our eagerness to accept the conclusion that a computer has given us. And so like figuring out how to put humans in the loop in ways that don't just like, serve as a rubber stamp on what the computer has determined is something we really need to work out. Thank you, everybody. I'm happy to take any questions if I have time, which I leave to shopping.
And, but she's not here.
Nobody's telling me to step down.
So back on the cell phone thing, a lot of my cell phone is backed up in the cloud, whatever that means. Well, so if they come from recipe and I see them coming, so I run over my phone with my car, rendering it useless.
Mm-hmm.
Then have they, in effect, get a search warrant for my phone and stick the information down?
Yeah, if the information is backed up in the cloud, then just like they can get a warrant. I mean, they need a warrant to look at your phone. They would need a warrant. It's essentially the same rule. They would need to get a warrant and they would need to describe the information they're looking for, but they couldn't even do that if it's backed up somewhere.
Okay, so the physical phone is not important.
I mean, that's literally what Riley was about, right? It's part of the reasoning of Riley. It's like, well, why would the rule be different for whether or not my phone is backed up or whether or not I had it in my pocket when I was arrested?
Yeah, the stop and frisk and stop and fingerprint practicing grand weapons. What if someone refuses to comply? What are the consequences of that? And has there been any cases where somebody was arrested for refusing?
Yeah, well, interestingly,
Suspicious person, not a suspect.
yeah, well, so that's interesting. Part of the police's argument actually in that case is they said, oh, well, these 15-year-old kids who were stopped by the police and kindly asked to give their fingerprint did so voluntarily, and they were not in fact seized. The Michigan Supreme Court saw through that and said, no, sorry, shenanigans. When you stop a 15-year-old kid and accuse them of a crime and don't really make it so that they feel free to go about their day, you have seized them. Neither one of them tried to refuse, so whether or not they could have faced resisting officer charges or something like that, if they had refused, I'm actually not sure how that might have played out.
Is there a mechanism for making sure that once the court declared the breakout, they can erase all those fingerprints that were captured?
That was not part of the case, no. Gotcha.
Do you have examples where a warrant would not be needed because the third party that may control or possess the data considers that data also be their property and hand over to law enforcement willingly and voluntarily?
Yeah, to be fair, this is not an issue I've litigated or read cases on, and you've been a public defender, Josh, so let me know if you think I'm getting this wrong. In general, the Fourth Amendment allows somebody else to sort of consent to the search of shared spaces, right? So if the police come knocking on my door and I say, do you have a warrant? And my wife says, come on in, they can come on in. So I would expect if it's legitimately shared data, that a search like that would likely be upheld. So if it's on the shared computer that my wife and I have, and she's like, sure, take a look. I probably am not going to have an argument for suppressing the information. On the other hand, if she takes my cell phone and is like, here's Phil's passcode, go to town, I think courts would probably have a problem with that, but I haven't seen a case on it, so I don't know for sure. Well, you had a question.
Well, I'm curious. I'm never aware there was something like shadow dragging, but I can understand that as a technology, somebody might save time. And it sounds to me like it's something that accesses the public web, but I'm also aware that the dark web is simply that part of the web that somebody needs a passcode to get into or a special link to get into. So when I worked for a company, we were considered a legitimate company, but we're in the dark web. Does shadow dragging, and then we know the dark web has things on it that I don't want to mention at a conference, and I don't go there.
For that matter, the public internet has things on it that I don't want to mention at a conference.
Yeah, that's true. Really think what's the line these days, and gosh. So with that in mind, is shadow dragging knowing in these political times with this information that's out there where you read articles and you're like, what? With reported sexual assaults, with all these different things that can appear to be one way, but maybe another way. Is that also something that shadow dragging does, or how
The short answer is I'm not entirely sure how deep Shadow Dragon goes on this, and what its full range of capabilities are. When I was interviewed about this a few years back, and I did a little bit of like research just on what was publicly available about Shadow Dragon at the time. And one thing that really struck me is it purported to be able to scrape information off of WhatsApp, but then everywhere else that it described its capabilities, it talked about looking at public basic things, and of course your WhatsApp chats shouldn't be like on the public web or like. So I am a little bit confused as to the scope of Shadow Dragon's capabilities. I was confused then. I don't know, Lisa, do you happen to have any knowledge about that?
My knowledge also from public news stories is that it can scrape the dark web and does, and also things like Amazon and dating apps, and not just social media.
Yeah, right. If you've got a public shopping list on Amazon.
And like I said, using Fourth Amendment questions, using First Amendment questions, because of course, will sometimes look at it and say, well, it's publicly available.
But so were the fake Russian Facebook things created,
Right, and
that's fascinating. I'm really fascinated, thank you.
Well, thank you so much, Kalamazoo, for inviting me and giving me the chance to speak on these subjects, which are near and dear to my heart.